Why don't you go ahead and get started and take your seats.
You guys look like it. No,
Welcome everyone to the January 16, 2026 meeting of the Tennessee Post Commission. We'll get started. Do I have a motion to adopt our agenda?
Mr. Chair, I did notice one little small either typo or maybe a maiden name on page 3, on number 6. in the Camden Police Department. Constance McCoy, and the first sentence is disdain. So I don't know if that's.
I see. Any insight, Director Bell?
Come on, computer. We'll get through some problems. No worries.
Mr. Chair, I'll go ahead and make a motion that we accept the agenda with that change if needed.
All right.
It should be right.
So you're making a motion to amend this section to reflect this right instead of missing.
That's right. And then adopt the agenda as written.
Second.
We have a motion by Commissioner Wright, a second by Commissioner Parton. Any discussion? All those in favor say aye.
Aye.
Any opposed? Ayes carried. Moving on to administrative matters.
We'll do the roll call. Commissioner Carter.
Here.
Commissioner Doggett.
Present.
Commissioner Green.
Here.
Commissioner Jackson. Commissioner Jeffers. Commissioner Lane.
Here.
Commissioner Parton.
Here.
Commissioner Russell.
Here.
Commissioner Spangler.
Here.
Commissioner Wilbur.
Here.
Commissioner Wright.
Here.
Vice Chair Leggins. And Chair Bevel.
Here.
Chairman, you have a quorum.
Excellent. Thank you, sir. Any other administrative matters?
Yes, we'll read the disclaimer. All post commissioners have previously agreed to recuse themselves from any vote that would constitute a conflict of interest. The most obvious of these would include issues that involve our own departments or some we know personally. Because we have already agreed to this, it should be noted that on routine matters, it will be assumed non-verbally that these commissioners have abstained from that vote. In bigger, more controversial issues that may have more overt conflict of interest or may have an appearance of impropriety, those applicable commissioners will still verbally abstain from those votes.
Thank you, Director. Moving on to the approval of our minutes from the December 12, 2025 commission meeting. I believe they are on your iPad and been emailed to us.
If no changes, make the motion to approve.
Second. Motion by Commissioner Spangler, second by Commissioner Parton, to make no amendment and move for approval. Any discussion? All those in favor say aye.
Aye.
Any opposed? Ayes have it. And a report from the decertification subcommittee hearings held on January 11th, 2016. That was in January 15th, 2016, or 2026. I love it. It's already that day, January 15th, 2026.
In the matter of Donis Bucci of the Chattanooga Police Department, the recommendation was a default order of certification. In the matter of Miles White of the Coffee County Sheriff's Office, the recommendation of subcommission was a 2-year suspension. In the matter of Elizabeth Wendling of the Memphis Police Department, recommendation was a default order of decertification. In the matter of Naisha Williams of the Memphis Police Department, recommendation was decertification. In the matter of Joshua Byers of the Munford Police Department, default order of decertification. In the matter of Christopher Vest of the Tullahoma Police Department, that matter was recommended to a formal hearing. In the matter of Hayden Bilbrey of the White County Sheriff's Office, he has signed an agreed order of suspension.
We have a motion to adopt the report.
Commissioner Green, motion to approve.
Wilbur second.
Motion by Commissioner Green, second by Commissioner Wilbur to adopt.
Harden will be abstaining on the Cobb County vote.
All those in favor say aye.
Aye.
Any opposed? One abstention on the Coffee County vote. Moving on to appearing before the commission for waivers for pre-employment, we have the Alamo Police Department for Ricky Lee Allen. Smith side.
The Alamo Police Department requests a criminal record waiver for Ricky Lee Allen. In September of 2021, Mr. Allen was charged with DUI first offense in Madison County. In February of 2024, Mr. Allen was found guilty of the charge and has since satisfied all court-ordered sentencing fines and fees. Is there someone here from the Alamo Police Department? Yes. Good morning. If you would just step to the lectern and identify yourself for the record, please.
Jeff Sales, Chief of Police, Alamo Police Department.
Welcome, Chief.
Thank you, sir.
All right, who do you have with you today?
This is Ricky Allen Jr. He's the person I'm asking the waiver for to put him to work for the police department.
All right, Mr. Allen, Junior, if you want to step up and kind of tell us what happened, give a little insight, and the commission might have some questions for you.
Yes, sir. Good morning, Commissioners. Mr. Bellin.
Yes, sir. Thank you.
It's a pleasure to be in front of you. Obviously, I wish it was under different circumstances. My plan is, so you know, hopefully to continue into law enforcement at your grace, obviously. I'm a little nervous and happy about today, so please excuse me. So you just want to know about what happened, sir?
Yes, sir.
So on September 16th, I was pulled over by a fellow officer. I did not know him at the time. He stated that he didn't know who I was, but I was arrested for DUI that night.
Was anyone? Go ahead, sir.
I don't wish to make excuses for anything because I obviously should have done things differently that night. But I stand here as a better person. I have completely turned everything around. And I don't blame anybody but myself. I wish I could have just done things differently. And it would have been a different outcome, but I dealt with the things that I had to deal with that night. And I have been committed to doing everything correct today.
What was your blood alcohol content that night?
I did not get blood, sir.
Okay. And let's see. I understand you were employed full-time when this happened.
Yes, sir.
Agency.
Excuse me. Yes, sir, I was. I humbly say I was actually the top performing police officer in the department at that time. I love my job. I hope to continue to do this job. I believe this job. This is a passion of mine. I spent 5 years doing it at my own expense as a reserve deputy for the Madison County Sheriff's Office to begin with, and went full-time in 2017.
After this incident, were you dismissed from that department?
Actually, just got dismissed from the city of Jackson in November.
When was the conviction?
So he was terminated from the Jackson Police Department, November 17th of 2025. Knowing the Jackson Police Department, they were notified of the arrest, he was placed on suspension while criminal matters were pending. Once that was finalized, they then decided to terminate. He is done with everything in court. He was convicted and appealed, and the appeal was denied.
Okay. That was explain it.
And that was as recent as August
Okay.
of 2025.
Mr. Chair, I will need to abstain.
Okay. Thank you. We do have one abstention. Does the commission have any other questions?
Excuse me, I didn't mean.
No, go ahead. Feel free.
I just want you to know, I want the commission to know that I haven't had anything to drink since 22. I'm an avid runner. I'm fit for duty. And I hope that I can continue on serving. That's my passion. It's what I want to do.
Thank you. Mr. Spangler?
Yes, sir. Mr. Allen, can you tell us what happened that night?
Sure. Specifically, I went to a friend's house. We actually walked down to a bar. And, we did have some drinks, played darts. From my memory, it was approximately 6, 7 o'clock. We walked back to the apartment. Maybe hour and a half later, something like that. And I went through the steps, what I thought was to be correct, and we stayed there for a couple hours, ate, drank water. I'd been up for a 36-hour period at that time. So fatigue probably had a lot to do with it. At the same time, I probably should have just stayed there, but I ended up driving home. I don't think that I was over the limit, but with all the things considered, I should have just stayed. It was a lapse of judgment. It will never happen again. It will never happen again. Alcohol doesn't have a place in my life. So, but I ended up getting pulled over. There was 3 supervisors on scene. I knew them personally. I paid for a lot through this. But I was detained for about 2 hours and had to go into jail.
I noticed in there it says implied consent too. What was that about?
So at that time, it was dismissed.
What was dismissed?
The implied was okay. The implied consent was dismissed. I'm sorry. So it was improperly read at that time. I didn't give blood. It wasn't read to me properly, and at that time I was defeated. I felt betrayed and defeated. And after that 2-hour period, I was give out. And hindsight, I wished I would have done things differently. But once it was over with and I had to deal with the situation I was in, I complied with everything. I got everything done. I went through everything I was supposed to go through. And for the last 4.5, 5 years, I woke up not being able to do what I want to do. So I paid dearly.
Thank you.
Yes.
Mr. Doggett, what vehicle were you in when you were stopped?
That was in my personal vehicle, sir.
Thank you.
Yes.
Mr. Seals, I'm Commissioner Green. I've read your letter several times and hearing you testify today. I'm not getting a feeling of remorse. I get a feeling that you are upset that they arrested you when you knew you were doing something wrong. You've been in law enforcement for a period of time. You still refuse to take a breathalyzer, even though you said you thought you were okay. You thought you were okay. Why didn't you take your blood?
Yes. Sir.
It's almost like it's their fault for impacting your life when you're not taking any blame for what could have happened if you'd been in an accident while you were drinking. So I'm a little concerned about. I don't get a feeling of remorse in this letter or testimony.
Okay, I see where you're saying that, sir. And I didn't want it to be that way. And at the time, I think I felt some resentment and some anger and stuff like that until I knew it was my problem. At that time, I was angry and I was hurt, but I more or less wrote that so you knew what happened. I'm not angry at anybody. I'm more or less trying to prove to the commission today that I'm not that person. I promise you, I will not fail. This is what I want to do. This is my love, my heart.
Yeah.
And you have my commitment to it. And I felt that way too. I understand why you said that, and I agree with you, but that's not where I'm at. I'm not angry with them. I take that responsibility because if I wasn't there, then I wouldn't have been dealt with that issue, period. So thank you for that.
Commissioner Carter, quick question. How long have you been in law enforcement?
I started in 2013 as a reserve deputy in Madison County. I left there, excuse me, I didn't mean to.
Go ahead.
And then I went to Jackson Police Department in 2017, when I came here to be certified.
So Jackson terminated you after they found out, your DUI arrest? Is that why you got terminated from Jackson?
I got put on leave, and then the ultimate answer to your question is I did get terminated. I did not quit. I got terminated.
Okay, so this came up during their background investigation, I assume?
Yes, sir, from my recollection, I actually called Chief Corley and asked him for my job back. And he knows how serious I am about this job. Unfortunately, this is something it's gonna be with me no matter what. It's a mistake I don't want to pay for the rest of my life. Unfortunately, it has been. And there's a lot of things that played into that, and I made that change, so it will never happen again.
So what did the chief say when we called him back?
He knows how passionate I am. Since there was so many other people, it's just me. There's so many other people involved in the situation. He didn't think it would be fair for me to come back to the department.
Okay,
Is what his words were.
I'm gonna reach back in time for a minute. 2002, tell us about this domestic violence assault charge that you had.
In Humboldt, sir?
Yes, sir.
Okay, I was a new father, and this is in 25 years ago.
Yeah.
I was a new father and new husband, and it was dismissed also, but it really wasn't much to it. I was brushing my teeth in the morning, and there was an argument about me holding the baby, and I ended up just reaching out and grabbing the baby and holding him, and the police were called, and they ended up taking me, but it was dismissed. I never put my hands on nobody. But it was just a new mother, new father thing. And at that time, it was just, I ended up going.
Alcohol not play a factor in this incident?
No, sir.
Okay, thank you.
Alcohol will never play a part in my life again, ever.
Commissioner Russell, Mr. Allen, what do you do now?
I've been in the custom cabinet business for a little over 20 years. I've done that the whole time as well.
And where did you go to the police academy at?
Here, sir.
Okay. And you was very well trained in DUIs while you were here?
I would say so.
And you thought that you were in good shape to drive that day?
That's a good question. Probably not. I regret getting in the vehicle, period.
Do you have anybody with you?
No, sir.
And you said the implied consent was not read correctly and it was thrown out of court. Have you made any arrests dealing with the implied consent?
I don't remember ever arresting anybody for DUI, sir. And if I have, it isn't many.
Okay. Was your license suspended at all?
Yes, sir.
How long?
For a year.
Okay, so when did you get your license back?
24, 25, I can't remember. I think it was 20, I think it was the beginning of 25.
And you was convicted in December 2024?
That sounds right.
That would put you getting your license back in December.
Yeah, it was after. So the conviction didn't uphold till after the appeal, which was in 25.
So that means your license was suspended until December 2025?
Well, no, actually what they did, sir, is they stayed everything except for they couldn't stay the driver's license suspension. So my license got suspended immediately in 22, I think after the court case in 22. And then, so I did that, the interlock device and everything, and I got my license. They stayed everything but the license suspension. And so it's been so long, I apologize, but I don't remember the exact dates.
And what have you learned from this?
I have paid through friends. I have learned that alcohol doesn't do anything but take. And if I didn't put myself in that situation, which will never happen again, you have my word. Then if I wasn't there, it wouldn't have never happened. I made a mistake. I was fatigued. I got in the truck. I did drink earlier that day. That was my fault, 100% my fault. And I apologize for making it sound like I was casting blame. I really wasn't casting blame because I know it's my fault. I just wanted you to know what happened, and I kind of went into some detail, but there was a lot into that night. But I did blame I tried to look for blame for everybody, but I realized it was my fault, and I changed me. In 22, I changed me. I didn't change them. I stand here before you as the strongest person that I've ever been.
Have you had any alcohol treatment since then?
No, sir. Quit alcohol, and is the answer.
I appreciate the outlook that you got. For me, it's just too short of time, been less than 5 years. So whatever happens here today, I wish you the very best in whatever you do in the future.
Thank you, sir. I appreciate that. And I would be willing. I know you like to see that 10-year period. I would personally be willing to provide drug and alcohol tests every month for that to write up that 10-year period. I'm that certain.
Thank you.
Commissioner Wright?
All right, Mr. Allen, a few things. One, like you just said, several on this commission do like to see a 10-year period. You made a mistake, and for that mistake, there are consequences. Now, I appreciate the fact that you've done what you could do to curb and mitigate that. The 10-year for me, some of this commission or 5 is for just the general public. Actual law enforcement officer, I think I even hold it to a little bit higher standard than the general public itself. So I'm not going to be able to vote to approve this today, and we get through discussion. Make a motion.
We'll go ahead and accept the motion and move to discussion.
I'll make a motion to disapprove.
Commissioner Green, I second.
We have a motion to disapprove by Commissioner Wright, a second by Commissioner Green. Any further discussion? All those in favor of the motion to disapprove, say aye.
Aye.
Any opposed? That's carried. I'm sorry, sir, your motion was denied. I do congratulate you on your sobriety and wish you the best on that. Please keep that up. Make the best version of you.
Thank you. Have a good day.
Thank you. Thank you.
Moving on, I believe to waiver to attend another academy.
The Camden Police Department requests waiver to change academies for Constance Nicole Wright. In March of 2025, Ms. Wright attended the Tennessee Law Enforcement Training Academy and did not complete due to failure of the obstacle course. The agency is requesting the waiver so Ms. Wright may attend Walters State Law Enforcement Training Academy in April of 2026.
I see Lieutenant Latimer just unmute yourself. Are you with Camden?
Yes, sir.
Right, I'm sorry, you couldn't hear me. What can you tell us?
Entered a waiver for Officer Wright, who failed to qualify the obstacle course at Toledo on 2 occasions. Officer Wright stated that she would pay her own way if given the opportunity to attend Walters. After discussing with the chief, Chief expressed he had all the confidence in the world in Wright, but also understood that our administration would not take on the expense to send Wright to Toledo for the 3rd time. And when she expressed to Chief that she would pay her own way, he agreed to sponsor her as an employee. I, as GDI, along with Officer Wright, have been in contact with Walters, checking on the possibility of the April class. That looks promising. and therefore the waiver was entered.
Excellent. Is Ms. Wright on there with you?
Yes, sir.
Yes, sir.
Mr. Wright, what can you tell us, what improvements have you made and make you ready for the academy?
I've been running ever since then and keeping myself in shape, getting ready to go back.
You ready to go?
Yes, sir.
All right. Any questions from the commission?
Russell, motion to approve.
Second.
Motion by Commissioner Russell to approve, second by Commissioner Pardon. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, your request was approved. Best of luck. All right, moving on to administrative waivers.
Thank you, sir.
Thank you, Commissioners.
On to waivers of the 6-month rule.
The Mount Pleasant Police Department requests a 6-month waiver for Trevor DeWade Roberts, hired December 22nd, 2025, is unable to begin training due to class availability. He's scheduled to attend Toledo in 2026.
Motion to approve.
Russell, second.
We have a motion to approve by Pardon, second by Commissioner Russell. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion to approve carries. Moving on to our consent agenda. It is attached on your iPad and then also on paper. Do you have any questions or anything?
There's no additions or any changes. I'll make a motion to approve. Commissioner Wright, second.
Motion to approve by Spangler, second by Commissioner Wright. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. New business annual academy reports.
The following academies request approval of their 2025 annual academy reports. These are required by post rule to show that these academies are still in compliance with the academy rules.
Do you have any questions or the motion?
Thinking everything's good.
Everything's in order, yes, sir.
Commissioner Spangler, make a motion to approve.
Second.
Motion by Commissioner Spangler, second by Commissioner Pardon to approve. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Moving on to decertification appeal process.
The commission discussed process for handling pending decertification appeals through the administrative law judge. Our legal staff have done a phenomenal job of wading through some of that backlog of formals that had been piled up for a while, sending those to the ALJ and getting those scheduled and clearing those out. And just as we've seen an uptick in decertifications that get submitted to post, the subcommittee is sending more to formals and we've had more appeals. So in an effort to kind of relieve some of the backlog that is now getting created through formal hearings through the appeal process, we're asking the commission to consider giving us the process and the authority to move some of those appeals to an ALJ process. A lot of these appeals are from defaults. They're appeals of decertification where there's no new evidence, no new witnesses. They're coming right back before the same people that have voted to decertify them. If there's nothing new, they're just coming right back in front of the same group of people. And they're just appealing because it's in their rights due process to appeal. It actually benefits them to go to a third party instead of coming right back for the commission. So something that we just wanted to float and see the appetite for the commission to maybe kind of speed things up and not create another backlog.
Commissioner Green, will we get a report back on the progress and what action they took?
So certainly, what we've done in a lot of these that we have actually brought to hearing is once the order becomes final, we report to you guys whether they've been decertified. That's happened. I think Ashley sent 3 orders become final. We reported those to y'all. The others have almost all, by the time we've served them and whatever, either ended up settling, surrendering, GLAs. So that 3-year backlog y'all voted for a year ago, 2 years ago, completely cleared out. We've got 2 cases that have aged to that 3-year mark since. Everything else is within the last 3 years. So we're looking at, if we take every case that is currently pending in front of this commission, about 1.5 years worth of hearings, including yesterday, not including yesterday, to get caught up to where we are right now. So just the opportunity, even if it was the defaults or like we said, like appeals with no new evidence to bring a report to you guys each month. We can try those cases on any Tuesday morning with an ALJ, any Thursday morning with an ALJ. We don't have to wait for that once a month hearing slot. And we were hoping to save those hearing slots for the ones the disciplinary committee feels need the full commission like last night. Or the ones that have the head of an agency or a significant question of factor law that we feel like the commission really needs to hear. For example, disciplinary hearings we've had the last couple of months that have appealed, or it's stuff that we kind of know where you guys are gonna fall. And so certainly just open for discussion.
I think the default decertifications, that's an automatic, we can send to the ALJ because it was default and we had service notifying them of the process. And in regard to that, I don't think it would be a bad idea to bring a report every month to us of which ones you intend. And we vote to go ahead and send that to an ALJ and start clearing that backlog. You think next month would be the first month you can bring that report and
For defaults or for?
just overall, any of them we want to refer to a.
We could do a month by
ALJ.
month kind of request and give you guys the high level facts, just so you remember which of the ones we did.
What's everyone else's thoughts?
Commissioner Wright, I think that's not just the defaults, but also the ones that the subcommittee went ahead and made a motion to actually take revocation against their license, because as Director said, before this body, it was already enough of a 3 to go no, so it's really no need for them to come back to us anyway.
I agree.
And the one the subcommittee voted on yesterday is a prime example. If she should decide to appeal,
There was
we're setting up a formal, getting a judge. If there's no new evidence, no new witnesses, nothing new for the commission to consider in reversing their decision. We're just kind of spinning wheels.
I just have a question. So taking yesterday as an example, we had an informal, but the formal that we had, they introduced a lot of evidence that the informal committee did not have. So are you saying we would only throw those to the ALJ where we know there is no new evidence? They say informal had it all. Is that legal?
Or if it's what they're suggesting is we can bring a report to you monthly on here, the ones that you have voted on, default or otherwise, that have appealed, which ones would you want to hear in person? Which ones would you want to refer to an ALJ? That may be a better process. That would probably funnel some to an ALJ to speed up some things. And then the ones that you want to hear, you can make that decision.
I think, for example, yesterday, we were on the informal, we referred the one we discussed at our formal hearing yesterday back to the full commission. That would be one we would want to continue. But for instance, I think of the Memphis officer yesterday, that one was a unanimous decision. I believe they could brief us on that if she decides to appeal. And then from there, we could probably send that to an ALJ.
Right. Thank you.
If that would be how I'd envision the process. Is that kind of what you were describing?
Just, yes, for clarification, you're asking for like a report that we would get for next month. So would that be a report of the default that we, the default decertifications that have appealed that we're asking to send to the ALJ? Or would it be a report of both that default and then the other appeals that we have as well?
I would say it's any appeal that you feel comfortable sending to an ALJ, if you can just bring a report of that.
Okay.
And then brief us on the facts to refresh our memory, and then we can vote to say, yes, let's proceed to the ALJ and help you clear that backlog.
And then, but for informals where the informal subcommittee just, or not just, but refers it to the full committee, doesn't make the decision on decertification, those will still we're gonna assume those are gonna be set for full hearing with the commission. Is that?
Similar to yesterday, I think that's still the temperature of the commission, is it not?
Yeah, Commissioner Wright, the one thing that I was thinking about on these defaults that might even speed the process even more than that, do they have to go to, if they appeal on the default, could we just reschedule them back to the informal and then maybe sort it out there? That might be a faster process of getting some of those out.
What was the UAPA said it has to go?
Well, our rules may say that UAPA wouldn't. UAPA doesn't even really contemplate our informal process anyway. Right. So it would just be our rules. I'd have to take a look to see. I think our rules are such that it does say 30 days, it's appealed. If you appeal even a default, then it goes to the full commission, although, like we're talking, you all could vote to still send that to an ALJ. I think that just the default position would be that if someone appeals a default decision, that it would, is presumed to go.
So for clarity for us and the public that's listening, if we do this, give the process from informal to formal or informal to administrative judge. Does that appeal get to come back? If they don't like with the administrative judge, then they can appeal to the full board. Is that right?
So,
For a formal?
so the way that process works, and actually, that's correct me if I'm wrong. Once they get the initial order from the judge, they have a period of time to ask for reconsideration. Does that go to the ALJ or does that go to the commission?
Well, originally it would come to the ALJ. I believe, if I recall correctly, they could request a reconsideration
By
to the commission, and then the person would just,
have a formal hearing. Or review the record.
it just be a review of the record, and then they'd have to go to chancery. We're sort of dealing with that with the case right now. Well, you'd be the only one that know anything about that, Mr. Trevor, but it'd be similar to that.
I just don't want to get us in a position where all of a sudden things are being handled downtown. And then we have somebody come in, stand at that podium and make us all look like Clarabelle the clown because it's not been, we've not hashed it out in this room that we were all appointed to sit here and hash it out.
And,
If that
and I,
makes sense.
and I think the process of, the month, bringing it to you guys monthly could help, because even yesterday, I talked to a couple of attorneys, cases of, right now, your rule is older than 3 years, and they've said their preference. Oh, I want to go to the commission, or, oh, I wish we could just go in front of the ALJ. So I think we could certainly in that monthly report include whether that conversation's been had.
So could clear it up. So could we just before you go to ALJ, could we get every month, can we get a list of that with a little clip note of what the case is about, and then let us give you a thumbs up or thumbs down?
I think that was the intent. That way it went to the informal and then it would appear on that report. So it's in front of our eyes twice before it goes to an ALJ.
And Sheriff Department, just to clarify, I was just looking at the notice of rights from one of the ALJs I've done. And it says that, after the initial decision is made by the ALJ, the party has 15 days to file an appeal to the commission, and commission put in bold. So, and this was an ALJ alone case. So if a respondent were to appeal an ALJ ruling, it would be appealed to you all, the commission. And so they would, at that appeal, you all would hear the appeal. It would be limited to the record, but the commission would be hearing that appeal.
So I just don't want the people to lose their right to come before us.
Yeah.
So under that plan, it would begin at the informal. And then if it got referred to the ALJ, it would come to us as a full commission for that referral. And then after the ALJ, if they seek to appeal that decision, it comes back to us.
Yes, and that's
Okay.
for, that last part is notice of rights, like that's separate and apart from y'all decides.
Gotcha. So that potentially three appearances before us, including an appeal process. That's right.
Yeah, Commissioner, and back on the default side, I can see, because it takes a lot to prep for these cases. If they appeal a default, then y'all have to basically prepare for a trial, even with an administrative judge or us. Is there a possibility that we can change the rules or vote around to get that back to the informal? Because that still seems to me like that would be the quickest way to move on with a lot of those, to keep y'all from having to basically do that. I don't know how many defaults appeal. Sounds like there's.
Yeah, I don't think we've got a ton, but I mean, there's certainly a few. And I think maybe in that monthly review process, that's something that we could outline which one are defaults and if that's the decision of the commission to, hey, we're going to punt that back to an informal reschedule and to come back, I think that's certainly acceptable with the rules of the UAPA law.
We're pulling up the rule right now, just to show that one.
Commissioner Green, do we need a motion for this?
I believe so. Do you want to get clarification on that really fast and then we'll entertain one?
Give us just.
This Commissioner Green, my understanding is that in the cases of appeals or default certifications, our legal people will provide us with a list of those appeals and a brief summary of the facts, of which we decide whether it goes to the administrative judge or the informal or full formal. The commission still makes that decision based on reporting out on those cases.
Yeah, and I think legal's just double checking the rules to make sure that in the event that a default was appealed and you guys want to send it back to an informal, if that is allowable through the rules. I think the rules say that.
Yeah. Yeah, I think, I don't think this.
So certainly, okay, so I think the answer is yes. If somebody does a default appeal, I think we have to bring it to you guys at the full committee, full business meeting and say, can we refer this, remand this back down to the disciplinary subcommittee? And that would give them a second bite at the apple to show up on Thursday. But it would not take away their right to appeal that second opportunity to a full commission hearing.
So if I'm understanding you correctly, Commissioner Green, you're making a motion to get a monthly report of the appeals that come to the attorney's office. And from there, the commission will decide where they would like to send those appeals.
That is correct.
With a brief reminder of what the facts of the case are.
Brief summary, yes.
So we have a motion on the floor. Go ahead.
I'm sorry to ask one clarifying question. The current 21 cases that we have pending, do you want an assessment of which one of those would fall into this new category, or do you want us to start fresh with this one?
I think we could probably spend the time helping clear some backlog.
Another clarifying question.
Yes.
With, so we have some that are already scheduled, so we would keep those off of the report, because we've already given those individuals their notice of hearing and they've set a date. But never, that was it.
Okay, I think the ones we have scheduled we'll keep, but any others you can brief in the report. We'll take a stab at that next week or next month. Well, we have a motion, we'll forward, we have a second.
Commissioner Wright said.
Motion or a second by Commissioner Wright. Any other discussion? And again, this is just to get a report with a brief reminder of the facts every month on the appeals that are filed, and we as a commission will decide where to send it from there. All right.
Thank you, guys.
All those in favor say aye.
Aye.
Any opposed? The motion carries. Moving on to Grundy County.
The Grundy County Sheriff's Office requests reinstatement of certification for Tyler Brent Milliken. Mr. Milliken entered in a 1-year suspension of his post-certification on June 21st of 2024. His suspension has been completed, and per the rules, anybody that is coming off the suspension must come back before the commission to get reinstated. Grundy County is looking to employ this individual, so they're just following the process of bringing him before the commission to request that reinstatement.
Great. I see there's a couple folks up here. If you'll identify yourself, please.
Tracy Brown, Chief Deputy for Grundy County Sheriff's Office.
Thank you.
Tyler Milliken.
Thank you, sir. All right, so you've been on suspension. Can you tell us kind of what you changed and how you're ready to enter back into law enforcement?
Yes, sir. So I entered suspension around June 21st, 2024. I was terminated from Tulsa Police Department for policy violations. Since then, I've been working armed security at Arnold Air Force Base. And I'm really ready to hit the ground running and get back into law enforcement. It's my passion. I was working at Franklin County Sheriff's Department, corrections, made my way up to sergeant. Lost 250 pounds to go to the police academy. Worked out every day very strenuously. passed the academy and began my career before this happened.
Excellent. What can you tell us about what happened at Tullahoma, and how would you correct that?
Yes, sir. So I was put on administrative leave for policy violation, which was violation of our pursuit policy. Now, what occurred during that pursuit policy was there was a subject that had felony warrants out of Franklin County. I'm very familiar with him from working corrections in Franklin County. And another officer pointed out that he was pulling out of a gas station. This other officer was right in front of me, observed the subject driving the vehicle. He informed me that a week earlier, prior to that incident, that he ran the subject and had a suspended license, at which time I initiated a traffic stop and the subject fled. At that time, our pursuit policy said that you must get out of the vehicle for 2 minutes, stop immediately. I did not stop. I maintained my presence in the area in case the subject wrecked. Since then, I completely understand why policies are in place, and I understand how violation of one policy can reflect multiple policies.
What happened with the body worn camera?
My body worn camera was activated. I think what the issue was, I believe, is that it may not have been activated when I initially activated my blue lights. But it was activated as soon as I got out of the vehicle at the accident scene where the subject wrecked his vehicle. I interviewed multiple witnesses on scene who had essentially followed the subject in a roundabout way and stated that they didn't observe the police behind him. There were 3 different times on body camera where 3 different witnesses approached me stating which direction the subject ran. And my rebuttal to them was, I don't care where he went. I know who he is. We'll get him later.
Refresh my memory. Was this a pursuit where the policy either said parallel or perpendicular, and you were driving, you claimed you were not in violation because you were doing the opposite of that?
It is. And that came to play through accident investigation courses. And, you want to describe lines and directions, and that's kind of how that, I turned right and the subject continued straight. We also had a 911 call that came out where a citizen called 911 and said there was a reported reckless driver.
Do you still stand by your decisions that day, or?
No, I should have pulled over. A policy violation is a policy violation, no matter how you look at it. But like I said, I believe that one policy violation kind of reflected off other policy violations, which led to me violating the orders, the general orders.
Legal, before we start discussion, kind of what are our options as a commission on this?
Basically just the opportunity to talk to him about it. If his suspension is over, he just has to show that he has a hiring agency and that he's ready to go back, based off of the 1-year agreement that the commission made. So y'all ask him anything you want, but we do have to reinstate.
Okay. Does the commission have any other questions? Commissioner Link?
Commissioner Lane, did your policy say that you were to automatically disregard, or did a supervisor disregard you and you continued on anyway?
A supervisor got on the radio and said, don't pursue. And that's how I violated that policy, because I didn't stop and get out of the car for 2 minutes.
Okay, thank you.
Commissioner Russell, what are you doing now, Mr. Milligan?
I work in armed security at Arnold Air Force Base.
Okay. I just want to say thank you for using this experience as a learning experience. I think it's going to make you a better officer in the future. So I'll make the motion to approve.
Thank you very much.
Commissioner Wright, I will second.
Commissioner Russell has made a motion to approve. Commissioner Wright with a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed?
Horton abstained.
We have 1 abstention. Best of luck, sir.
Thank you all for your time.
Thank you, commissioners.
Moving on to late submissions of pre-employment.
Late submission of pre-employment to Coffee County Sheriff's Office in the matter of Kirtland Parsley, hired May 29th, 2025. Posted and received the paperwork until December 12th, 2025. no further actions required. We have everything that we need. And since the sheriff is going to recuse himself, I'll go ahead and speak on his behalf. And we post his GDI. Just call it what it is. We stole your guy, and
I'm blaming it on your employee. Your employee.
Yes, sir. And we believe that in the transition and crossover of us employing Mr. Ray, that some things were dropped and fell through the cracks, and once they were brought to the agency's attention, everything was rectified and corrected. So everything's all squared away.
And he is your employee.
Yeah, yes, sir. I'm reminded every day.
Russell, motion to approve.
We have a motion to approve by Commissioner Russell,
Commissioner Green, I'll second.
second by Commissioner Green. Any discussion? All those in favor say aye.
Aye.
Any opposed?
Pardon us, Dave.
One abstention. All right, motion carries. Moving on to Kingsport. We have someone on from Kingsport.
And this matter, the matter of the Kingsport Police Department, he was hired in August 5th of 2019. This was an officer that had retired and come back as a part-time reserve. And the new GDI, when going through the paperwork, saw how many hours this individual was working, was aware of the post rules, and kind of caught this and made us aware of the issue. And we worked with them to rectify that situation. So kudos to Kingsport for catching that and wanting to correct the issue and bringing that to our attention. So we do have everything we need in that matter is resolved.
Awesome. I see Kingsport's online. Who do we have with us?
Lieutenant Thomas Waite and our GDI Sergeant Brevin Addington.
All right, well, Director Bello has said everything's in order, and you were able to catch the mistake. We appreciate it. Do we have any questions or a motion from the commission?
Commissioner Green, motion to approve.
Carter, second.
We have a motion from Commissioner Green to approve, a second by Commissioner Carter. Any discussion? All those in favor say aye.
Aye.
Any opposed? Ayes have it. All right, thanks, Kingsport. You're good to go.
Thank you guys, and we appreciate all the help.
Moving on.
In the matter of Obion Police Department, Cameron Lee Rollins, hired November 7th, 2024. We received the paperwork October 31st, 2025. All documents are satisfactory. We have everything we need.
Do we have Obion on there? Who do we have with us?
Chief Jerry Flutie.
Hey, Chief. Director Bello again said everything was in order. So anybody have any questions for the chief? Not doing so, we'll entertain a motion.
Commissioner Wright, motion to approve.
Lane, second.
We have a motion by Commissioner Wright to approve, second by Commissioner Lane. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. All right, you're good to go, Obion. Thank you.
Thank you, sir.
Have a good day, Chief.
You too.
On to our legal report.
So an agreed order for surrender for Isaac Boaz Pearl. Mr. Pearl was employed by the Tennessee Highway Patrol from August 2022 until February of 2024, when he was terminated for violations of general orders for unsatisfactory job performance, unbecoming conduct, and abusive position. And a member violated relations related to an improper traffic stop. On or about September 29th of 2025, he agreed to surrender his post certification.
So this is a surrender. We have any,
Commissioner Wright, make motion to accept.
Commissioner Green, second.
we have a motion to accept the surrender by Commissioner Wright, second by Commissioner Green. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Moving on to Mr. Stone.
We have an order to surrender in the matter of Danny Ray Stone. Mr. Stone pled guilty and waived his right to a jury trial regarding an official oppression charge in Cumberland County. On December 16th of 2025, he agreed to the court order surrender of his post certification as part of his plea agreement.
Commissioner Wright, motion to approve the agreed surrender.
Lane, second.
We have a motion to approve by Commissioner Wright, a second by Commissioner Lane to approve the surrender. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. We have a settlement proposal from Mr. Bain.
Cody Bain is one of our older cases. He was initially terminated for a violation of their general orders for no call, no show, and he also received a criminal charge which has since been expunged. He was out of law enforcement from the date of this incident on 12/5/21 until you look on a cadence, I think it was like 2024. He's since been to transition school. He's gainfully employed by an agency and represented by Attorney Jack Bird. What we're asking for is basically a time served suspension from the time he was terminated. That would count towards, let's see. Yeah, January 1st, 2022 through January 1st, 2024, which would be a 2 years time served suspension. He's now successfully graduated from transition school and gainfully.
Update. He was hired by the Jackson County Sheriff's Office in June of 2025 and has since resigned in good standing on September 28th of 2025.
You told me that first. But either way, he's been in transition school. He was out of service for 2 years, and the only thing that legal would be able to present to you guys at a formal hearing would be the no contempt.
I understand, and I think it's my opinion that the department was able to handle that in-house on their own. Does anybody else have any discussion or entertain a motion?
Commissioner Ryan, make a motion that we, approve a 2-year suspension during that period of time.
All right, we have a motion to approve the proposed settlement.
Spangler, second.
We have a second by Commissioner Spangler. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Moving on to Mr. Gregg.
The attorney for Mr. Gregg, Mr. Hull, are you present? Is present here to present their proposed settlement order to you. I helped him craft this, but it was their presentation to make. Investigator Creed has worked closely with Mr. Gregg since he became employed at Irwin Police Department and does have some good news for the commission as far as what Mr. Gregg's been able to do down at Irwin. So if you guys have any questions for Investigator Creed, he's also available after the presentation by Attorney Paul.
Step to the lectern, identify both of yourselves, please.
Yeah, I'm Attorney Todd Hull, representing Doug Gregg.
Doug Gregg. All right, sir. Thank you.
We submitted humbly this settlement offer to the commission for consideration. Mr. Gregg is working with Washington County Sheriff's Office. Was resigned / terminated and went to work for Irwin Police Department, where it's been since April of 2024. Since being employed with Irwin Police Department, he is promoted from patrolman to investigator to now investigator / training officer. We've got a letter from Chief Buchanan, the current Chief Irwin, that cannot be here today. Also for the consideration of the commission is a certificate from the state. Investigator Gregg was one of the first responders that was trapped off the Unicoi Hospital, Unicoi County Memorial Hospital during the flood of Hurricane Helene, and was awarded a certificate and medal for life-saving efforts at that time and search and rescue efforts after Helene. He's been working as training officer for the last couple months, worked closely with Mr. Creed, who, as the commission probably remembers, had some training issues with Irwin PD. I believe Investigator Gregg had worked diligently to get them back on track and has successfully got them back where they need to be as far as training. He's a 29-year law enforcement veteran, wishes to continue as a law enforcement officer.
And Mr. Gregg's offers in the conclusion paragraph of the settlement on page 3. If the commission has any specific questions about it.
Commissioner Wilbur, I remember this because this is the officer who was told to work his magic, and he believed that that meant he could pick a lock on this woman's house and enter this woman's house, and she was in the bathtub nude. I remember this very well. I can't remember what we did at the informal.
It was referred to a full commission and it's set for next month if the commission does not accept this later.
I think, just my personal recollection, he read the room and read the temperature of the room, saw that the informal was about to decertify him because of those facts.
And Commissioner Green, that's my recollection as well, is it was, if I remember right, basically burglarized a home to go in, picking a lock. And we talked about Fourth Amendment issues and burglary at the informal.
I was not president of the informal.
He was. I'm addressing him.
Correct. And for the commission's, purview, those charges against the homeowner are set for jury trial in June. The state is prosecuting, the lady for vandalism. And I believe Investigator Greg would state that, he used the least restrictive method to enter the home, instead of kicking in the door. He did use lock picks to enter to keep the damage down.
Does the Fourth Amendment authorize an officer to pick a lock of a person's home? Where in the Fourth Amendment is that about? Is that reasonable?
It is written under TCA 40-7-103 that
He
says
committed vandalism. Where's the?
felony vandalism.
Where's the exigent circumstances to pick a lock of a person's home or residence? You can't answer because you can't. I don't know how that case is gonna go with that Fourth Amendment violation blatantly staring in there on her arrest. He created a huge problem for the DA's office.
Any other discussion?
Mr. Ryan, I make a motion that we, disapprove the settlement order, moving forward with the full commission.
Commissioner Green, I'll second.
We have a motion by Commissioner Wright to disapprove the settlement proposal, second by Commissioner Green. Any further discussion? All those in favor say aye. Any opposed? All right, sir. It has been disapproved. We are still set, I believe, for next month. Thank you. Thank you, sir. Moving on to post-investigative reviews.
Post-investigative report findings investigation conducted on the following agencies and officers. Kingsport Police Department, investigated part-time officers working hours equivalent to full-time hours pursuant to TCA 38-8-101. Investigator Creed will present the report findings. And this is related to the waiver that, or the report, the late pre-employment packet submission that we discussed already.
Post-investigator Creed, good morning. This is a continuation, like the director just said, of the other waiver that was requested by Kingsport PD. This is something we would never have known about until they brought it to our attention. It was two officers who worked for the department full-time, and then he retired. And then he came back to the department to work in a part-time capacity as school resource officers. In the department size, they thought they were part-time because they were under 40 hours a week. But according to Post, they have to be considered full-time because they were working more than 20 hours. So it was just a paperwork issue of categorized as part-time according to Post's eyes, but it was really supposed to be categorized as full-time according to Post. Since then, I believe it's all been corrected and the new GDI is on board with the rule and being very transparent. And like I said, they brought this to our attention. This is something we would not have known until they brought it to our attention.
And honestly, how this ended up as an investigation was they had reached out with some questions about the process. And just as a matter of making sure that everything was on the up and up, we assigned it as an investigation. And because our process requires that any investigation and findings be reported to the commission, that's why we're here today.
Commissioner,
We're just contacting the box.
We have a motion to approve by Commissioner Green. Do we have a second?
Commissioner Wright, second, that'd be no further action on this as well.
That's correct.
So a motion to approve and no further action by Commissioner Green, second by Commissioner Wright. Any discussion? All those in favor say aye.
Aye.
Any opposed? All right, it is approved. Moving on.
All right, the matter of the Tennessee Law Enforcement Training Officers Association investigated for missing EVOC tests for in-service.
Investigator Creed, once again, this was, work came about from another investigation I was working on where I was looking for EVOC results or EVOC tests from a 2022 incident at the Training Officers Conference. While looking into someone who received post credit for that class, and was on the roster for that class for the Tennessee Training Officers Conference. I was trying to locate the actual EVOC test because the person was not physically in the class. So we had someone who was not physically in a class, but got credit for that class. So according to post rules, you have to take a test for an EVOC class. Everyone's been doing that for how many years now? So I wanted to actually get a copy of that test and see if another officer forged that test for him, where he received post credit for that class, or if there was no test ever given to that. So the person who was responsible for the record keeping for the Training Officers Conference is Brian Childress, who's the GDI from Millington Police Department. I contacted Mr. Childress at Millington about the tests. He said he would look for the tests and see where they were. So after we played phone tag back and forth about trying to find these tests for a long period of time, they have at the Millington Police Department, they have a storage trailer where the Training Officer Conference keeps their records in. He said it was too hot at the time to go looking for the records. Like I said, we played phone tag back and forth for these records. He said he looked and pretty much couldn't find it. He also came up with an answer that the records were in his government issued vehicle, and his government issued vehicle was involved in an accident and was at a repair shop. And then at the repair shop, the records got damaged. It possibly got damaged inside the vehicle because the windows were busted out of the vehicle. So it got rain damaged and probably got discarded at that time. When I asked for a copy of the accident report for the date of the accident, it turned out that the accident took place prior to the Training Officers Conference. So those records could not have been in his vehicle that are missing. So after he wrote a memo, it should be attached on the emails that's what happened, that the records were possibly in his vehicle. So I did a surprise visit to Millington Police Department and met with GDI Childress. And we personally did an inventory of the records for the Training Officers Conference. I was able to locate 2021 and 2023. 2022, all the tests and all the records for the EVOC class were not there. Also, 2024's was not there. When speaking with Mr. Childress on 2024's test, he said that Mr. Baker, who is the actual EVOC instructor for the training conference, possibly had those records in Gatlinburg. That's where the conference was. I did reach out to Mr. Baker, who also is has a PSID number. He's not a current law enforcement officer today, but has recently been a law enforcement officer. So I reached out to him about these records, and he said that the 2024 test must have been misplaced or lost when you're packing up the conference, and that's why there's no record for the actual tests themselves. So as of today, I could not verify if someone forged that 2022 EVOC test, even though someone got credit for that class. I don't know if there was no test given. I don't know if there were what took place in 2022 to help that other investigation because of two officers that are certified in the state of Tennessee.
Sheriff Harden.
Go ahead, Chair.
How many individuals of this group are involved? How many people?
So there's several people on the Training Officers Conference, there's several executive board members, but the people that I was able to determine, the actual person who administered the test and instructed the class is Rick Baker. The person who is in charge of the scanning of the in and out and attendance and the records was Brian Childress. So those two individuals are the only ones I could locate that would have know about of these exams or.
And Mr. Creepy, these are folks that are over the training of the Tennessee Law Enforcement Training Association.
That's correct. They're board members.
And this is the conference that most of our training officers and GDIs, it's the premier training association, premier time of the year that we go, you go, everybody, this whole meeting moves to that conference for that. I mean, everything's dot the i's and cross states, right?
I believe in 2025, they used a different system for scanning and tests and stuff like that, but
Do we need to bring some folks in here for an informal?
Rick Baker is currently not a certified law enforcement officer, but he does have a PSID number and he can get employed by the department at any time. Brian Childress is the GDI of Milton Police Department.
Well, I mean, you kind of give a dog eat my homework story here.
Well, what really disturbed me is when he said the records were in his vehicle, and then I asked for the accident report, and it happened before the training officers go over.
I've got some commissioners along with I that have a problem with deception, integrity, and lying.
I couldn't actually prove lying, but obviously, the records were somewhere, and I don't know if they were shredded, disappeared, misplaced, thrown in a garbage can.
But do you by chance know how many people would have attended that HVAC class?
That EVOC class, there was several, I think 400 or 500 people attend the conference itself.
That would be a stack about, like, yeah, so, like, you know, we could, couple of reams of paper signs, right?
Yeah.
I'm gonna make a motion to have said individuals brought in for an informal.
Thank you. Do have a motion on the floor. We'll get to discussion. We can get a second to the motion or if it stands. And will you restate your motion, Sheriff?
My motion is to have, what was his name?
Brian Childress and Rick Baker.
Those individuals scheduled for an informal.
We have a second.
Commissioner Green, I'll second.
We have a second from Commissioner Green. Commissioner Russell.
Commissioner Russell, I just want to understand the process. How are these classes approved through post?
So the conference itself is submitted for post approval, so it's a mandated class. So it was approved for an EVOC mandated class, and according to state law, a test has to be given. So it was post approved numbers for the whole conference.
Do they have to send you the curriculum to post?
That's correct.
And when they send the curriculum, do they send the test that they're going to give?
And they should, it should have the test because then part of the requirements is no true false, stuff like that. So it has to be approved as a mandated class to meet the criteria. So yes, sir.
Did post check the file and see if the test was in your own file?
Well, we have the original, we have the actual test that should have been given or was given, but we don't have the answers or who took the test, their scores. All they submitted to us was pass, fail for individuals from that year.
Okay, and what is missing is the answers to the test.
The actual individual tests that the officers took.
Okay, I understand now.
We have in his ACADIS profile for the original investigation, it says a pass for that class.
Okay.
Which means a test had to be given for them to get a passing score. But the person was not present in the class.
So you don't have the answer sheets?
I have the answer sheets that, like, what they go by to grade the test, but I don't have the individual officers' answer sheets or the test. So what's typically given out is the class takes place and then they hand out the test to be given out. The people take the test, it's given in and then it's scored, and then those tests are kept or something like that.
Okay, so what I understand is post has the test, post has the answer page or sheet to check the answers officers give, but post is, or they do not have the individual test that was given to the officers.
That's what I was looking for, yes, sir. But no other jurisdiction gives us the actual individual officer test afterwards. They retain those records themselves. Their record, most agencies are government agencies, they have to keep those records on hand and stuff like that. This is a private organization, so.
And how long are they required to keep those answers?
That would be a question for the commission or legal.
That was going to be one of my questions, was a retention period.
I'm not sure what the retention period would be for that, like a private association, something we can look into.
State records, we have record retention, but private.
Most agencies do it in-house or have, the agency keeps the records in-house, but this is a private organization. So that's why I am presenting on the two individual officers, and we have no oversight over the actual organization.
Are there any post rules requiring an agency to keep these answers for a certain length of time? Post rules?
I don't think there's anything specific in the rules that directs an agency to keep specific documents. Something we can look into, and, you know, I think for a grander discussion, you know, the association itself as an entity, being that it's a private organization, doesn't necessarily fall underneath the post rules. However, they are using the Milton Police Department or other agencies in the association as a proxy to submit their training to post for approval, which I think
It's the
does
same,
create an
it's the
issue.
same for our sheriff's association. It's the same for the police chiefs association.
Yeah,
We have
so
to
I think
fill
that-
out,
the
when
lesson
we
plan-
fill out those documents
Yes.
to submit, I mean, if I falsify that training document, whenever I go to the sheriff's association about my post-certified training that I'm supposed to receive as a sheriff, that's no different if we're doing in-service training inside the department. And that's the same, and these are post-certified law enforcement officers of the state at the premier training association that we respect or expect them to pass along these rules and trainings and updates and basically, is it my understanding, Mr. Creed, you were investigating something else that led down a rabbit hole that led to
Yeah, that's
this?
correct. This was not a
And you were
complaint.
trying to verify for some other investigation, which has led into basically what I'm seeing is, I'm not, I don't want to say the word cover up, but I'm gonna say the word cover up. I mean, it was just some paper shuffling and then all of a sudden my understanding is you've latched on to something here that's caused some folks to, the more they talk, the more trouble they get in.
Well, I found 21 and 23, but not the records I needed.
Well, that's outrageous. They've got them from 21, but they don't have them in the middle. And then, you know, we had a car wreck or then a trailer.
And no 24s.
Right now, and stacks, 400. I mean, either you got them or you don't. Commissioner Lane.
I was just gonna say, I'm gonna have to abstain. I don't know this Childers, but I started my career at Millington in '87, so.
Commissioner Wright. Commissioner Wright. Do we know how GDI Childers wound up being the responsible party to keep up with these records?
I think just because he has a location that's gated in, that the trailer stays at, and he's a member of the board of the Training Officers Conference Association. I do not know why that would be an internal question for that organization. He's a GDI of Milton Police Department and could probably submit trainings to get post approved and just kept their records at his facility. There was like, when I searched the storage trailer, there was sweatshirts, t-shirts and all the swag and other material and business records. So he didn't just keep training records at his location. It was pretty much all the organization's information that they had on site.
The one thing I have concern about on the motion that's on the floor now is, and then the legal might be able to help us out with this, it's kind of like yesterday having the decertification for violation of a policy, and it wasn't in policy. And with Post not having anything saying that they have to retain these records, do we have anything? All we have is, we think there was some deception.
And just to add something else, I believe in 2026, when I spoke to Mr. Baker, I don't know what his role is now. I believe he was the president at the time. That they are probably going to stay away from mandates in 2026 at the conference because of this information that I brought to their to them.
I agree, but I guess I'm looking at this in two different approaches. I worry about the policy violation, but also we have an active duty law enforcement officer that made statements to you, a post investigator, even though it has to do with a private entity. He made statements to you. It's no different than us, you know, investigating something that might have happened with a private security company.
But if you look at the statement that he wrote, it's very vague. The documents are probably in my vehicle. There was nothing I could say that he specifically lied or stuff like that. It was very just vague the way it was written.
And I guess what we're looking at is with the informal, I believe the sheriff's just, let's get it up here in front of us and let's talk about it and see what comes out for both of these subjects. But the other avenue I have is they will be teaching some post-approved courses. And folks that go to this conference are using government money to take these courses, whether it be registration fee, hotels, gas, per diems. And I think us as a post commission want to make sure that they're adhering to all of our standards. So I don't know if that needs to be more of a rulemaking discussion on making sure they're squared away with their lesson plans and class presentations before November of this year, how we want to do that. But I feel like we need to take two different approaches on this. One with these two individuals, but two with the organization, just making sure they're in full compliance.
Was there not somebody indicted out of this mess?
Actually, that came up when I was doing an inventory of their training records. There was information from an indictment and a law, possibly lawsuit of mishandling of funds and stuff like that.
Well, somebody, I think you was talking about, I recall hearing something, somebody signed in and didn't show up and was shopping instead of in class. Is that right?
That is how this investigation.
Comptrollers got involved.
That is how this investigation started.
I mean,
It was
yes,
chief of Monterey Police.
the associations are associations, but Mr. Chairman just hit the nail on the head. I mean, I pay my department, my local tax dollars go to my GDIs to go to that conference in government vehicles on a government dime to go up there and get the updates, particularly from these people that are supposed to be the best of the best, the GDIs, to network, to talk about, I mean, they go up there and talk about us a lot and how to keep from having to be in here in front of us. I think we're getting in the weeds about a private association. Yeah, they're their own entity, but so is the Sheriff's Department of Coffee County, Knox County, and everywhere else. We're our own entity, but we're there with tax-paid individuals. There for state mandated trainings, and yeah, they don't even have to submit for any training. No association, they can just go up there and have a gathering, but it is going to affect their numbers, because if it's not some kind of post-approved training, then what's the use of me sending my folks up there? I mean, if they're just going to go up there and sing Kumbaya and cook s'mores, we're not getting nothing out of it. Watch Bear. Yeah, Watch Bear is right up the candy store for the fourth time. I mean, that is one of the largest associations in the state of Tennessee with the most responsibility. I look at it bigger than us sheriffs and the police chiefs. I mean, us sheriffs can get together in a room and have war tales all the time. But the training conference, folks, that's where we send folks up there to really invest in what's going on in law enforcement and how we're moving forward in the future. And those folks have a responsibility. And if you're on the board of directors or whatever it may be of that thing, you've got, I mean, where's my guys' records? If I had some kind of internal, I'd have to call to verify that my folks are in that class. It's not there. Then we're all in trouble. Am I looking at this wrong?
Commissioner Green, I guess I've got a question, because then I've been on both sides of this, both with the department and with the private entity. So for the Training Officers Association, do they just submit a certificate and says, I was there for 40 hours worth of training, including mandatory post requirements?
So it's changed.
Or do they fill out a specialized training form that actually they put down, I attended, and they fill out this many hours at this conference?
So they provide their attendees a certificate that they can then take back to their individual agencies for their individual agency to submit to us to receive credit for that training.
So the individuals are not responsible to come back and do the supplement or the specialized training submittal that we would have to do. Like if I went to Montgomery, Alabama for something and I could do the substitution form.
Right. They don't do a substitution form. They fill out.
So this is all pre-approved.
Correct.
That's what brought me to my other point of how we want to proceed in November. If they're going to be doing those, if they get credit for post hours, we want to make sure this doesn't happen again. To your point of, if it turns into an internal, we need those records.
Commissioner Beverly, if we could just put on the record that Commissioner Wright has left, but that we still have, Commissioner Wilbur has left, but we still have.
Okay. Do we have that recorded? Great, thank you. Commissioner Green.
I'm going back because the Tennessee Chiefs Association, each individual attendee that day fills out checks that I attended this training. So they personally are on for that. And if a test is there, at least my understanding, at least, and for my conference, is we hold the records for 18 months. So that gives a time for a period that if a question came up over a year past that conference, we would have those records. But again, maybe, I'd say post, I don't want to make more work, is don't accept because you have a certificate that they attended all 40 hours of that conference. Is when they fill out for specialized training, that individual they have to affirm that I attended how many hours. And that puts it on the individual officer. And for us, because I do a multi-state conference, is my mandatory is a separate event. So
well, everybody breaks it down.
It does.
With us, we have to fill in a little bubble sheet and it gets scanned in with their post number.
Yes, I feel like we might we have two different issues here. I agree with you, and I think that might be more of our next agenda item being rulemaking hearings of what we want to make the rules for the trainings to actually be. We had that discussion. We do have a motion and I believe a second on the floor to refer Mr. Baker and Mr. Childress to an informal hearing that would address this part, and then we can discuss about the actual association training in our next item. Do we have any further discussion on that motion?
Commissioner Wright, just one more thing. The one person that was signed in and then not at that training, have we done anything with that person?
That person was indicted by the Cumberland County grand jury. He surrendered his post to us, and is scheduled for a trial in 2026.
So we have a motion on the floor and a proper second. No more discussion. All those in favor say aye.
Aye.
Any opposed? Motion carries. They will be referred to an informal hearing. Moving on to our rulemaking hearing session.
All right, everybody, get ready to hear my voice. We're doing the rulemaking hearing for the rulemaking package, and as a part of that, I've got to read you all certain specific scripts, and then what we'll do is go through each of the chapters that's being changed. So I'm going to be moderating this rulemaking hearing on behalf of the Post Commission. And for the record, Ralph, can you identify the staff members that are going to answer any public comments or questions on the rule?
I'll be the one answering questions.
Okay. It is Friday, January 16th, 2026, and we are at 3025 Lebanon Pike in Nashville, and it is 10:58. This rulemaking hearing is being conducted pursuant to Tennessee Code Annotated Sections 4-5202 and 4-5203. The purpose of this rulemaking is to solicit comments on the proposed amendments to 1110-02, which is certification, 1110-03, curricula and course of instruction, 1110-04, which is in-service training requirements, 1110-05, forms and documents, 1110-06, administration of income supplements for law enforcement officers, 1110-07, basic training academy minimum requirements, 1110-08, part-time, temporary, reserve, auxiliary law enforcement officers, special deputies, and 1110-09, criteria for waivers. The proposed rules were developed by the commissioner and by the department based on the following: statutes, a review of the existing rules, input from the deputy commissioner, assistant commissioner, director, and the post commission, input from the governor's office as well as legal counsel. Please note that copies of the red line version of the notice of rulemaking, which delineates the proposed amendments, are available at the entrance of this conference room. Any members of the public that would like to speak during the hearing and comment on the proposed rules should sign up on the sheets provided. Only those who have signed up will be permitted to speak. The rulemaking, or excuse me, the notice of rulemaking hearing was filed with the Secretary of State's office on November 7th, 2025, and published on the Administrative Register of the Secretary of State's website. Tennessee Code annotated 388104 authorizes the Post Commission, which is housed in the Department of Commerce and Insurance, to adopt these rules, or to adopt rules, pardon me. TCA 5-4-204A4 requires the department to present a summary of the factual information on which the proposal of each amendment is based. For the first one, which is chapter 1110-02, start. So we're going to take a 5-minute break, and we'll then come back and start going through the rules as delineated.
Thank you.
Oh, go ahead. Of course.
There
Like, here,
are
see, I'm not-
hard copies of the red line.
So the first chapter that is being changed is chapter 1110-02 certification. This rule amendment outlines the evaluation criteria for an officer who's trained in another state to determine whether the officer's length of basic training, years of service, and level of education achieved are equivalent to the state of Tennessee's certification requirements. And this rule amendment, with this rule amendment, it will not be considered a break in service, will not be considered a break in full-time service if an officer transitions from full-time employment with a law enforcement agency to certain enumerated roles. Are there any comments or from that section?
We've got some new members here and I know how this works. Commissioner Doggett, pay attention to this right here, this part right here. So if somebody applies here from California to be a law enforcement officer, there's going to be a scale sheet to compare their certification to our certification.
Yes,
under a point system.
yes, sir.
And somebody in this building is going to evaluate that sheet on a point system. Is that right?
Yes.
And they're going to take their syllabus if they can find it, because every one of these states do something different. And they're going to break down their training and put it to a points to see how it matches up to our 488 hours of requirements. That my understanding.
We're changing that process to, instead of comparing apples to apples and looking at, did you have 120 hours patrol techniques? Yes, I had 120 hours patrol techniques, 48 hours EVOC, 48 hours EVOC. Sometimes it's very difficult for our staff to look at what Texas did, and because they'll call something different and we get down in the weeds of trying to figure out what was EVOC, what was defensive tactics. And so what we did is we went back and did a study and research of the last 165 or 200 transition packets that had been submitted to us and looked at the number of hours that those other states have, the years of service that these transition students were having, and the level of education that they had. And so we base this on a model that Alabama does something similar, or so it's more of a, instead of you're looking at curriculum to curriculum, it's more of a point-based system where you're looking at not necessarily did you have X number of classes, but was your academy at least 488 hours in length? It was 900 hours. Okay, you get a certain number of points. I was an officer for 15 years. This gives you a certain number of points. I have a bachelor's degree that gives you a certain number of points. You have to have at least 10 points overall to qualify for each transition school. And so we were hoping that this would make it easier for folks while still checking boxes and making sure that they have the education and experience, instead of having to go back and find curriculums from 1982, because a lot of these states, after a certain number of years, that stuff just doesn't exist.
Well, I want to interject something real selfish like.
Sure.
And it's just nature, and I've got to do it because I'm one of two sit on this board that represent 95 other sheriffs. We're going to have an onslaught of people moving into our great state. They've been invited here. There's going to be an onslaught of officers move here from California, New York, Florida, wherever it may be. And we're starting to hear and see things of people coming here and, well, they're setting up shop for 1 year prior to a qualifying date, and all of a sudden they're experts in Tennessee, everything, in jails and all kinds of stuff, and they're going to want to run for office. Hey, that's their constitutional right. But we see what we go through here every month. And we need help through this, maybe with our General Assembly, but we're going to have folks coming in here from Timbuktu and running for office thinking that they know everything there is to know about our situation in Tennessee. Yeah. I just don't, yes, I want to recruit good officers. They're going to come in here from wherever to be deputies, to be police officers. It doesn't mean they're good enough to run the whole show. And I just want us to make sure that we're careful.
Well, and I don't think this rule change would impact
You
that
think it's
process.
tightening, you think it's, in your opinion, do you think it's tightening up because I know like Florida used to be, their training was it Florida it used to be? That
It was Georgia.
Georgia's,
It was Georgia. We had 488, they had 400, and we always had issues with, we were looking at the 3 high liability areas is what we were really looking at, was the EBOC, firearms, DT, and those hours matched the number of hours that we had here. And we always found that Georgia was like 8 hours short. We're making them come back to an academy and do an additional 8 hours of EBOC and then say that they were approved to go to transition school. But some of these guys were 17, 20-year veterans. I know one for a fact that he was from Colorado and he was an EBOC instructor at their academy, but because his academy class, the hours were shorter, we were making him go back through EBOC here. So I think this change is to address some of those issues. As far as the sheriff election goes, the statute still says if you're coming out of state, if you've got the 3 years in the last 10, you're going to qualify to run. So I don't think this impacts that.
yeah, but three years of Tennessee or 3 years from anywhere.
It just says you have to, yeah, it just says 3 years of full-time. law.
Exactly, and that's what my point is 3 years of law enforcement in Wyoming may not be is not the same as 3 years of law enforcement in Tennessee.
Right, but that would.
3 years in Oklahoma running jails out there is not the same as 3 years running a jail in Tennessee. And I know that's stuff the General Assembly need to address, but we have a tendency with our rules get way over here sometimes compared to what the General Assembly says, or the General Assembly will say, well, we're trying to do this, but post rules are way over here.
Yeah, and unfortunately, even if we kept the rules the same, the way the statute's currently written, they would still qualify.
Yeah, right. I just wanted to point to that.
This Commissioner Green, and since the sheriff's on his band, soapbox, I'll get in mine for a little bit. I almost feel the same way about federal officers coming in and just getting a waiver to come in. And federal law enforcement is completely different than local law enforcement, either on the sheriff's side or municipal side. But we allow that to the post. And that's a concern for me. The same thing, whether it's running for sheriff or coming in as chief, or even just coming in as a line officer, and they're going through very minimal training, if any, as they transition. So we'll get to that point, I'm sure, but I'll throw that in there too.
So Commissioner Russell, when these applications are submitted for the point system, is any kind of a CALIA accreditation considered?
No, sir.
And why not?
Commissioner Green, I can answer part of that. Part of it's money.
But in the
Smaller
CALIA,
agencies can't afford to be a member of CALIA.
but the individual is not CALIA. The CALIA is the whole department.
Yeah, the whole agency.
It would be the departments to make sure their standards are up to CALIA's professional standards.
Commissioner Doggett, I'll ask, since we brought this up, do we know if the Department of Commerce and Insurance will be submitting any statutory changes to that we talked about with the 3 years of Tennessee law enforcement?
That would be the governor's decision, but as far as for this legislative session, the department did not submit any legislative changes on that topic. But it's something we can talk about for next year. Sorry. Oh.
So you need a motion to adopt or?
Well, what will happen, and I have to read the part at the end too, but after today, we'll have the public comment period open for another 7 business days for members of the public. So at that point is when we would make any changes that have been requested. So.
And I think at the end, or if they have any recommended amendments, maybe they could vote, but certainly they can also submit written comments for the 7 days.
So are there any recommended changes that you all would like to have considered for chapter 1110-02? Okay, moving on to chapter 1110-03, curricula and course of instruction. This rule amendment is for reorganizational purposes, and it is just moving the transition school requirements from this chapter to 1110-07. And we thought it was a better fit there. That chapter deals with basic training requirements and minimum standards. Any comments on that change? Moving on to chapter 1110-04, in-service training requirements. This rule amendment makes changes to this rulemaking amendment makes changes to the in-service training requirements in subparagraphs A and B to mirror their respective statutory language. It also amends the statutory requirement. It also adds the statutorily required driving under the influence annual training. And it clarifies that there are no true or false questions allowed unless the test is developed by an equipment manufacturer and the test is for equipment certification. And finally, it clarifies that an agency can set a higher standard than the floor of 75% for passage if they so choose.
So are you saying on in-service for DUI training that there's got to be practicals? Is that what that means? You said no true or false statements, or true or false? Multiple choice? It has to be multiple choice, no.
So the post-commission rule has always said that, or it currently says that we don't allow true or false questions. The problem that we ran into is that certain manufacturers require that you teach their curriculum and use their testing instruments, such like TASER is a great example. TASER won't allow you to test and certify and be covered under TASER unless you use their materials. Their materials have true false questions. And so we've always allowed an agency to submit that and approve it and as an exemption to the rule. This just kind of puts our current practice into rule to allow that exception.
Okay. Kind of wished I had a GDI sitting over here beside me.
Got you covered.
Are there any more comments on that?
Question is, the length of time of that course, is it be, how would that be determined? 4 course or 4 course?
For which course, sir?
For the driving under the influence?
That, the statute outlines that it's a minimum of 2, I think it's 2 hours annually.
It's covered in the statute.
Yes, sir.
Commissioner Swain, was that 2 hours also for child abuse?
So actually the statutes for child abuse, mental illness response, and the DUI don't outline an hour requirement. They leave that up to the agency.
Okay.
So most, EVOC is the only one that mandates that it has to be at least 2 hours.
Okay. And firearms.
And firearms, yeah. By post rule has to be minimum 8 hours.
I've got another comment, and this is just, I think we've all seen the news of an issue going on. We have a requirement for DUI in-service training compliance for law enforcement hired after 2023 or assigned to the traffic unit. Is that something that we just want to expand to potentially everyone and make it a part of the mandatories, or is that even appropriate for now? What some other input?
I don't know how many police chiefs or sheriffs. I mean, yeah, I've stopped, said drunk, somebody else comes up and because the days of my training of arresting a DUI have completely changed.
Right.
And, I mean, if we make it mandated, that's going to change for investigators, detectives, narcotics, administration. You know, the street line deputy or officer, yeah, I mean, they needed to.
Are we not mandating it now for everybody hired after January 1st of 2023?
So that's by statute.
Yeah. But he's
Is it
talking
gonna
about
be-
backing it up.
Yeah, backing it up, and that's gonna be where I was gonna go with that is it gonna make it harder on agencies to schedule in-service when they got, okay, well, this group here hired after 2023, this group over here was prior, so that could be more.
Well, and what we've seen agencies do to handle that is they look at their own internal needs and they determine everybody on patrol is taking this regardless of whether you were certified in 1995 because you're on patrol. We'll handle detectives differently. There are some agencies that go, hey, this is just easier to make everybody do it, aside from the sheriff, chief deputy, chief, who may be getting their in-service training at their respective associations.
It would make the associations put this in for a bunch of sheriffs and police chiefs.
And
Whereas at home, in my in-person in-service, we put it in. So when I attend that, I go through it.
And that's kind of, I want to address the issue, but I don't know if a blanket mandate is what is needed. And I think maybe some input from TSA and Tennessee Chiefs Association might be needed. And if you can provide maybe some insight that agencies are trying to handle this, maybe not just by the letter of January 21st, it could broaden within their own internal, right?
100%. I think most of the agencies are handling this internally and making sure that people that need to have this, whether they're on patrol, just because you're exempt, because you were certified in 2005, you're still on patrol, you're going to be making these arrests, you're doing it. So I think agencies have a good handle on addressing this and making sure that their folks that need it are taking it without creating undue burden on administrators or folks that don't need it.
Well, and the point of bringing that up was we've seen what's going on nowadays with the news, and it shows, I want to highlight that our Director Bello here just said there are agencies that prior to this issue coming to light are taking proactive approaches. And I wanted to highlight that, but I'm painting on a broad stroke. I'm worried it could have some other implications. Thank you. Thank you.
Any more comments or questions about O4? Okay. Moving on to chapter 1110-05, forms and documents. The rule amendment changes the deadline by which an officer must submit documentation to post. Right now, it requires them to submit their paperwork on the first day of employment. This change would allow 30 days from their employment. It's being done just as a practicality. And this amendment explains that after the records have been verified and approved by post and uploaded to the CADIS database, an agency no longer has to keep physical paper copies of those records. And so those are the amendments to that chapter. Any questions or comments? Next is chapter 1110-06, administration of income supplements for law enforcement officers. The rule amendment establishes that all salary supplement paperwork must be submitted digitally, and physical paper will no longer be accepted by the commission staff. It also states that for officers who substitute their out of state basic training for certification and attended transition school, the officer is not required to complete 40 hours of in-service training for the year that they complete transition school.
Go over that last part again, Ms. Bell.
For an officer who is using their out-of-state basic training for certification and attends transition school, and that's how they're receiving their Tennessee state certification. In the year that they do that transition school, they are no longer going to be required to also take 40 hours of in-service training. So it's
Yeah, because they're getting it all right.
right.
Well, and this is something that we've seen in previous years and you'll see in a couple of months. Are those because the rules, the way they're written, require that even if you do transition school, you have to do 40 hours of in-service on top of that. And we consistently see agencies that, well, you went to transition school, why would you need to do in-service? And then they're stuck having to submit a waiver, and then the post commission's asking us questions like, well,
But you're waiving those administrative, you're looking at it, making sure they're complete, because I get hit with that all the time, like it'll be.
Well, and the biggest thing was that the rules didn't really specify what had to be in transition school. And as long as everybody's putting the mandates in.
Mark, is a new sheriff school also going to substitute for transition school?
Spoiler alert.
Oh, wow. Carry on.
Are there any more comments or questions for that chapter? Okay, for chapter 1110-07, basic training academy minimum standards. The amendment will no longer requires 20% of the 488 hours of basic training to be done in a seminar setting. This rule amendment expands the required emergency medical CPR training to include recognition and response to a medical crisis involving a person under arrest or in law enforcement custody. The rule amendment ensures that basic law enforcement academies provide the same number of training hours, 488, as the hours that are provided by Toledo. And the amendment adds a requirement that an academy strategic plan must be submitted and accepted by the commission before the commission will consider whether a new basic law enforcement academy has demonstrated compliance. Also, for reorganization purposes, this is a chapter that transition school has been added to. And finally, this rule amendment deems new sheriff school as an equivalent to transition school. I'll give you all a minute to read this piece. It's a little longer.
And we've had a few, as recent as the last election cycle, that have come before the convention and asked for a waiver of transition school. We've had a couple of newly elected sheriffs in 2022 that attended transition school. I think this probably just makes it even easier across the board for the whole group.
Well, and also, I feel confident that you and your staff will be on top of what the curriculum is. I mean, I've been through it. It's gotten longer. I'm glad to see the week-long jail model, which is years ago, it was only 4-hour block in 1 week. Now sheriff school is 2 weeks and there's a lot crammed in it.
Yes, and we're continuing to work with CTAS and the Sheriff's Association to put that curriculum together so the new sheriffs are getting exactly what they need to be in that role.
Are there any more questions or comments on that chapter? Okay. Next is chapter 1110-08, part-time temporary reserve auxiliary law enforcement officers and special deputies. And I'm just gonna say part-time when I read out this summary and not, but when I'm saying part-time in this section, it means part-time temporary reserve auxiliary and special deputies. So with this rule amendment, a person newly employed or utilized as a part-time law enforcement officer only has to receive the initial training of 128 hours if at the time of transition, they're not currently employed as a full-time law enforcement officer, or if that person has not had a break in service of less than 3 years. The rule amendment waives the 120-hour requirement if the part-time officer completes a basic law enforcement course within 3 years. The rule amendment clarifies that a part-time law enforcement officer does not have to receive the 40 hours of in-service training the same year that part-time officer completes the initial 128 hours of training. This amendment makes the employing agency maintain and upload training records in the same manner that they would for a full-time officer. And then, excuse me, this amendment adds a new rule requiring agencies utilizing part-time officers to add the part-time officers to that agency's data roster complete and submit an application for certification of those officers, report the part-time officers' work hours, and report any change in statuses in the same way they would for a full-time officer. And the certification is outlined is not, it's a,
Certificate of Reserve Officer Compliance.
thank you, it's a certificate of reserve officer compliance.
Is this where we get to have a discussion of defining what is part-time to post rules compared to iron wage? Is that in this section or is it down the road?
This is it.
This is it? Okay. Part-time by iron wage is less than 32 hours a week, correct? Is that right? I think that's right. You're considered a part-time employee for government. I think it's 32 hours. It's 32, right? Sure, 32 hours. Part-time but full-time law enforcement that you get to hold your post certificate is if you work in carrying a gun and a badge 20 hours a week. Now think about that. And we're seeing, and we've had trouble in the past where we've had folks working law enforcement at 2 or 3 different agencies. Matter of fact, we had a guy, was he chief in 2 different towns?
Mhm.
Considered full-time chief. I kind of got a little problem with that. You know, it's Tennessee has evolved and, you know, most roads are paved now. And most folks have a car and most folks have a phone. So there's not, you know, they're not doing the train and the telegraph and the town marshals anymore. But we've also got folks that go to work somewhere for 20 hours a week and have a full-time private job and decide they get to run for office. I have a problem with that too. Again, I'm saying selfish things because of the experience I've been through and other elected officials, but it's not fair to these police chiefs either. Do we need to have a conversation about upping what is considered full-time and part-time for post-certification at this point? The hours.
This is Commissioner Green. I would agree that it wouldn't be a bad idea to define that in this section. So it's actually in writing somewhere.
It's Commissioner Green, it's not fair to that full-time deputy sheriff or police officers out here working 40+ hours a week and overtime on our interstates, our highways, getting spit on, run over while somebody's over here in Podunk, Tennessee as a part-time police chief and gets to claim that same thing. I've got a problem with it.
I agree with you. My concern, I think that's what they're looking at. Is this codified or is this our own internal rule?
I'm sorry, Chair. The definition of full-time and part-time is part of the statute. And I'll just read the part-time officer. Again, I'm saying part-time to mean auxiliary, reserve. Part-time means any person employed by any municipality or any political subdivision of the state of Tennessee whose primary responsibility is to support the full-time police officer in the prevention and detection of crime, apprehension of offenders, and assisting in the prosecution of offenders for appropriate remuneration in measure with specifically assigned duties or job description. Part-time police officers shall work not more than 20 hours per week for a total of not more than 100 hours per month. Any police officer who works in excess of the maximum hours as specified shall be reclassified to a full-time status and must meet all the requirements for standards and training as mandated by post. In any situation where an officer is temporarily assigned for a period of 1 month or less. 1 month or less. I gotta read that sentence over. In any situation where an officer is temporarily assigned for a period of 1 month or less to work more than 20 hours per week or a total of not more than 100 hours per month, the officer shall not be reclassified to a full-time status.
Quick question, is that the statute or the rule?
Statute.
That's what I was concerned, and
Yeah.
so I agree with you, but that might be,
388101.
if we know any of the General Assembly, we might want to give them a shout.
Big old swamp talking. Yeah, you all understand what we're saying.
388101.
However, based on how the Post Commission has voted in the recent past, there was a situation, if you recall, in 2022, where a sheriff packet was challenged. And the matter came before the commission where the incumbent had sent his chief deputy to the jail, never changed the status in Acatus. And the Post Commission took the stance of, you didn't change his status. That's the official clock, that time counts. Would it help you until there's a statutory change to put something in the rules where the status has to show that you're full-time, as opposed to, which would make them jump through a couple of extra hoops to come send paperwork to the Post Commission to show that they're a full-time employee?
Well, this full-time by iron wage or full-time by post rule?
Well, we would have to go by what's in the statute and rule for the time.
And the statute, but the statute is not dealing with iron wage, the statute's dealing with the rule. In other words, if I go get in a patrol car and ride around for a city or a county for 20 hours a week, no more than 100 hours a month, I'm considered a full-time law enforcement officer.
Correct.
But the city or the county is paying me by paycheck, I'm considered a part-time individual with no benefits, no withhold, no insurance. You get it?
Certainly.
We got kids working at Walmart more hours than some of these folks that are considered full. And that's what I'm saying. I'm looking at the rule. Maybe we should raise our rule about full-time.
But would that have to start with the statute before you change?
Statute.
Yeah, the statute, the rule can never contradict the statute in a way that it makes the rule more broad. So this would have to start with the statutory change. And once the statute was changed, that would trickle down and apply to the rule, even during the rulemaking process, if that makes sense.
I would really like for my General Assembly members and people to get that, because it's a problem. And we've got a lot of little towns in Tennessee that people it's a little, and nobody would have ever thought, but it's the truth. It's okay, I've lingered on that long enough.
And just because I keep a notes, when you're saying you would like it to mirror.
I think if full-time,
the late wage
if the taxpayer's paying me for 40 hours a week or 37.5 hours a week, then our rule should be to consider a full-time law enforcement officer, you should have to put in 37.5 hours a week. Is that, am I?
Understood, yes, thank you.
I think we need to raise it from 20 hours to what iron wage looks at as full-time is full-time, part-time is part-time.
Got you.
Together with money and service. Did I say that right, Don?
Yes, sir.
Okay. I'm from Hillsborough, Tennessee.
And I think the purpose of that may have been to force those that were trying to work low hours to have to do basic and not use that as a loophole as well.
Well, we can also statutorily close in. I mean, if you're hired as a part-time officer, you get away with everything or go. I mean, even the constables don't even have to do it.
It's also, they got some work to do.
I'm getting there. I've only got a short time, Director.
Oh,
don't say that. Yes, you are.
You know where he's going.
Are there any more comments or questions for OA? Okay, moving on to the last chapter. Chapter 1110-09, criteria for waivers. This amendment clarifies the waiver of transition school will not be issued for an officer who has had a break in service of 3 or more years. 3 years or more.
And I know we've done it in the past, but it's screeched some folks and
Are there any more comments or questions?
Let me read through this one.
Oh,
Let's hope this one.
little transition skills not gonna hurt nobody.
No, and what we saw was that it was very difficult to, where was the line? You know, it became 3 years and 3 months, and then it was like, well, then 3 years and 6 months, and then 3 years and 11 months, and I mean, you have to draw a line in the sand somewhere, so.
No, that's how I am. If it says 3 years, it needs to be 3 years.
Yeah.
And the be considered on an individual basis. I mean, we're not changing that. That's kind of.
Correct.
No, I tend to agree with it. I don't think a little transition school will hurt.
Well, we had one in the past for chief deputy working for CTAS. He was down in the basement down here teaching the new sheriff's school.
Yeah.
I mean, chief, he was one of our instructors, John Rose.
Yeah.
And I know that.
Commissioner Lane had some input.
Yeah, I was just gonna say it, this was 6 years ago, but I fell in this category as well because I was working for Homeland Security, County Homeland Security Mercy Management. And so I was just like 3 days over the limit, which back then I think it was 5, but I had all the records going up. So I think, I mean, you know, I had the education, the FBI Academy, all this stuff. So I think that we should keep that depending on the position that the person is going to and what the background is, you know, keeping, if they maintain the post requirements during that time, whether it's in service, shooting, all that stuff, all that should be considered. So that's just some input from me.
Yeah, and you know, the way the rule's written and amended, it keeps that in there, you know, that you can consider it on an individual basis. And we've had a few, John Rose, I think Chattanooga PD came before us a couple of years ago with the gentleman that they had hired who retired from, I think, Secret Service, who was going to be over like their CID, and he had some very specialized ballistics training, and he was going to be assisting their CID in that avenue. So yeah, you know, it does leave that door open for the commission.
I think that's important. I don't remember exactly how far mine was over, but it wasn't a lot, you know, and I think there should be heavy scrutiny on those folks. That you should have all the proper documentation showing what you've done during that break and those kinds of things, but there should be some flexibility. So thanks for clarifying.
Sorry, are there any more comments or questions for Dasher Mountain? Okay, a regulatory flexibility analysis and economic impact statement are required for any rule that may have an impact on small business. These rule amendments do not have an impact on small business. Is TCA 4-5-228 requires any rule proposed to be promulgated shall state in simple declarative sentences without any comments on the merits, whether the rule or regulation may have a projected financial impact on local governments. The rule amendments will not have a projected financial impact on local governments. Director Bello, have you received any written comments?
I have not.
And I received confirmation from our ADA coordinator that we have not received any comments. And I was also listed on this notice and I did not receive any comments. And so at this point, just out of an abundance of caution, I don't really know if a rule, if a vote is required, but just gonna ask if you all would like to vote to move this forward. We'll be keeping the public comment period open for another 7 days. The comments are gonna be accepted until 5 p.m. Central Time on January 23rd, 2026.
You need a roll call vote or is that?
When does this, Give me the scheduling of when these rules would take effect.
Are you
Because
reading my notes? I feel like you just always spoil
I've only been here, I've only been here going on 8 years, Paul.
No, it's just that
When does
next
it go-
paragraph.
When does it go to the Secretary of State?
Well, it's already been filed with the Secretary of State, and that's why we're doing this rulemaking hearing today. So what is going to happen next is that these rules are going to be forwarded to the Attorney General's office for review. And then after approval, they're going to be filed with the Secretary of State's office, and they'll have responsibility for publishing these rules. And at that point, the 90-day clock starts. And during that 90 days is when the Joint Operations Committee
So it would,
and then after that 90 days, it'll become effective.
so you're looking at doing that this year?
I hope. Yes, yes.
Comply with the retrospective review, we need to get it done.
Yeah.
Because the reason that at least 4 of these rules were even on here, because it was part of the retrospective review.
I figured it would be sometime after January 20th of 2027 or something.
Understand.
That's why it
Sticking out to you.
It got thrown at us, didn't it, Ralph? It did right out of the gate.
So do you need a voice acclamation or a roll call vote?
Just the voice could be sufficient.
Do we have a motion for?
Should accept.
There's a motion to accept by Commissioner Green. Do we have a second?
Second, Lane.
Second by Commissioner Lane. Any discussion? All those in favor say aye. Any opposed? Motion carries.
Thank you. And so for the record, the rulemaking hearing is now concluded. Stated that.
2 things that I wanted to address with you guys real quick before we cut you loose. We are going to look at planning a meeting in West Tennessee. Perhaps maybe sometime April, May, June, we'll reach out to you guys and schedule some dates and confirm something. But we always wind up in Gatlinburg every fall, so we thought it was only fair to take the show on the road and visit our partners out in West Tennessee. So we'll be looking at some places to host and probably do a GDI class, since we're already going to be out that way, and then do our regular commission stuff out there. So we'll be in touch with some dates.
Just cover it more.
I like that.
Sounds like that's close to somebody.
Well, I'm just, Nashville's 3.5 hours, Memphis is still 2 from me.
Oh,
So
really? At your house.
Hey, we're good going there. What about the right place?
Yeah.
Plenty of room.
Well, and we'll probably reach out to our folks out in West Tennessee about a good location and, and figure that out.
Yeah, Carterville. I'll put Carterville on the map. We will gladly.
There we go.
So, yeah, so we'll reach out and, get some dates and make that happen. The other thing that I wanted to bring your attention, just, very briefly, we'll probably bring this into you in a more formalized report next month. In the event that you get some phone calls regarding online training in reference to V Academy, we're aware of the situation. We're just trying to figure out how big the issue is and what some solutions are. And so we'll bring that to you next month. So in the event you get some phone calls with some issues in reference to V Academy and online training, salary supplement, tell them to hang tight. We're aware, we're making some phone calls, we're getting it squared away, and we'll bring that to you guys next month. And there was nobody signed up for public comment. And so with that, we can move to the last matter.
Second.
Hold on.
If you were not aware, thank you. If you were not aware, Chief Faulkner has stepped down from the commission. So if you'll reach out to her, she felt that her calendar and schedule this upcoming 2026 was going to put her in a position to miss a lot of meetings if she didn't feel that was fair to the commission and put us in a bind for a quorum. So she went ahead and gave up her seat so that could be filled. So that was rather abrupt and sudden. And so I wish she would have been here to announce that herself. But we appreciate her time that she served here. She came on very early in 2017, 2018 as well.
She come on with some of the Mohicans here.
Yes, so many years of service, and we appreciate her words of wisdom. She was a bulwark of steadfast standards, and we'll miss her wise words and wisdom. She was quiet, but when she spoke, it carried some weight. So we appreciate her time here.
I want to thank our legal team over here for the work they've done. We put y'all through a lot of grief and challenges, but don't think that we don't recognize it. Oh, I'm sorry, I didn't try to say we as a team, but I will take into cut when it's in the other form. And put you through a lot of grief and challenges, but y'all do a wonderful job. Keep doing the work you're doing. And you're doing what you're supposed to do, and we're doing what we think, or I'm sorry, but thank you. I just want to.
Well, very much.
We do.
And this is Commissioner Green, I'm gonna go ahead and say, I want to appreciate the director who's been shuttling 2 jobs here the last few months, and I know that hardship, and I'm sure you're waiting a new director at the post, and I hope that happens, take some of that load off.
Hey, don't feel so sorry for him. He asked for it, just like we asked to get away.
Yeah, but it's nice to hear a kind word and once in a while, at least on this side. You don't swell him. On this side, we would like to thank him for his appreciation and work he's done.
Thank you.
All right.
We are to adjourn? We already have.
Sure.